All right, let's get started. Welcome everyone to Navigating Meeting and Events in Q3, featuring Legalese with the Ladies, powered by HopSkip. So great to see such good numbers for today's webinar. Before we jump into the agenda, first kind of give an introduction. Can you guys hear me? We see someone in the chat mentioning they can't. Are you, Barbara, Lisa, are you able to hear? Yeah, okay, cool.
Yes.
All right, awesome. It looks like everyone else can too. Great. So to get started, who we are, my name is Sean. I am one of the co-founders and CEO of HopSkip. For those who might not be familiar with HopSkip, we are a platform professional meeting and event planners use to streamline how they source and contract business events. So we work with planners on one side, we work with hotel sales teams on the other, as well as DMOs, CVBs, and NSOs. Lisa, do you want to introduce yourself?
Sure. I'm Lisa Sommer Devlin. I'm based in Phoenix, Arizona. I'm a sole practitioner, and my exclusive practice is representing hotels regarding convention and group-related matters. I've done this for about 30 years, and so I've worked with most of the big names in the industry, and I've also been happy to work with my friend and colleague Barbara Dunn for many years as well. Barbara?
Thanks, Lisa. Always a pleasure to work with you. I'm Barbara Dunn. I'm a partner with Barnes Thornburg in our Chicago office. Pleased to get to represent groups in connection with their meetings, travel, and hospitality contracts. And always delighted to be part of the HopSkip webinars. Thank you so much, Sean and the HopSkip team.
Thank you both. Let's jump in. So today's agenda is really going to be focused on two main things. We're going to first start off with providing a quick overview of what we're seeing in terms of industry trends, challenges, obstacles, and then we're going to jump in, primarily focus on the Q&A. So thank you to everyone again for submitting questions and noting the challenges in advance of the webinar. Your feedback is instrumental to us to ensure that we're providing good content during these webinars. So thank you again to everyone who submitted input. Before we get rolling, this is a standard disclaimer we make every time. Today's presentation is not legal advice. Please consult your attorney with any specific questions. Is there anything you want to add to that, Barbara or Lisa? All right.
I think that covers it.
So what we're seeing around sourcing and contracting hotels in today's landscape. Barbara, do you want to start?
Sure, absolutely. Well, again, thank you all for joining us. And it's hard to believe we're already in Q3 and talking about trends as the year's gone by, and definitely seeing a lot of movement in the marketplace. Usually Q3, Q4 for me is busy with helping clients review contracts with hotels and convention centers. And I'm pleased to say I'm doing a lot of that. So that's a good thing. I anticipate being busy hopefully through the end of the year. I know there's always a push to calendar year end. With that said, I kind of boiled my comments today into sort of three main takeaways, guidance, if you will, for those listening today. First is to be careful out there. And I would use the Hill Street Blues reference, but I'm afraid I might date myself. But just to say, they used to say on Hill Street Blues before the group went out for the day of the police that be careful out there. That's my first guidance, to say be careful. Slow down and really review contracts carefully. Review them once, review them twice. One thing that I've seen on both sides are contracts and language which seem to be pulled together quickly, a bit of a patchwork quilt in terms of dueling provisions on, attrition, on cancellation, different terminology throughout the contract. And so, what that really spells is, to me, a messy contract means it's not a good start for the relationship, and it's definitely not going to be a good roadmap. So just slow down, really review things. One thing I've noticed is that, some of you, when you review a contract, you might look at the subheadings and say, oh, okay, that's the section about attrition. That's the only place that attrition lives, right? Well, maybe not. And so I've seen contracts where language about one topic is put into a provision that has nothing to do with it under the heading. And so, you kind of get lulled into that, and your eyes might glaze over and you might review it quickly and not see it. So again, I can't say this enough. And, I say this to myself at the same time, is really slow down, review the contracts carefully. And when you're amending a contract, make sure you're amending it properly. Make sure you're including reference to the previous contract and all previous documents. So, but really important. And, these are things that Lisa and I see often when they go wrong. So definitely be careful out there. The second thing, be considerate. What do I mean by that? Be a reasonable person in the negotiation. Come to the negotiation in terms of what you can give and what you're looking to receive, and be reasonable about it. On the group side, many of you have had to adjust your meetings and events in the last couple of years. Maybe you've right-sized them. Maybe you've changed the schedule, you've changed the block. Whatever the case may be, being reasonable about your asks is important. And even things like concessions. Sometimes the concessions list might be from days gone by where you needed a bunch of suites and a bunch of all these different things. And now you need different things. Maybe internet's more important, or other discounts are more important. So really, be reasonable in what you're seeking and why you're seeking it. And then what can you give? Why do you want my meeting? What's my history look like? What's my group doing? What's going on in my industry? I think the more information you can give, the better in really selling that there. But be considerate to the responses, work through the negotiation. If there's an objection with the language or issue, follow it up. What's the alternative? What's the compromise here? At the end of the day, we're all stewards of our stakeholder resources. So whether it's groups and your owners or your members, or hotels, your owners, et cetera, we're all stewards. So, and we're all in it for the long haul, hopefully. So being considerate, I think it goes a long way. And I say that legal perspective, but I'll also say that as a business perspective, I think it's a good strategy. And the third thing I'd say is be cautious, somewhat related to the be careful, but in this way, cautious, I'm looking at it as really reflecting on your organization, negotiating the flexibility that you might need. It's the adage, hope for the best, but plan for the worst. And in that way, what if we have to, what if we don't pick up as many rooms? What if we have to, trim down our block? What if we have to increase the block? What if we think we're comfortable with the attrition, amount, and, maybe we're not? Can we change that? What about the food and beverage minimum? Is that based on old numbers? Can we have flexibility? And even all the contingencies that happen. Of course, many of you are back to booking contracts more toward a quote normal lead time for groups might be 4-6 years out or more, really building in the flexibility and the possibility of contingencies and making sure you're addressing them. So inasmuch that hopefully that you feel a good positive energy going forward for meetings and events, don't set that caution aside. Have the healthy caution, I think, would be a good way to look at that as you approach your contracts. Lisa, what are you saying?
Those of you who've watched these webinars, can you hear me? Yes.
Good.
Okay. Those of you who've been in these webinars and who've watched our legalese with the ladies videos know that Barbara and I tend to agree more than we disagree. And I couldn't agree more with everything that Barbara said. I'm seeing the industry going in a very positive light. As Barbara said, everybody's busy, and that's normal as we head into the last half of the year, but it seems to be much busier than it's been the last couple of years. And what I'm seeing in terms of busyness is not cancellations, not attrition, but negotiating contracts going forward. And so that's a great thing to see, that people are positive about the industry and back to booking meetings. I'm still seeing a lot of things being booked for 2024, but I actually got a contract this week for a meeting in 2031. And boy, 2031 sounds so far away to me, but you know, that's the way it works. So that's good. And everything Barbara said is true. Be careful, be cautious. I get so many messages from my clients saying, I need to get this signed by Friday, meaning today. And they send it to me yesterday and they expect me to give them an answer in 5 minutes. And that's not right for me. And it's not right for the hotel either, because everybody needs to read all these things carefully. And unfortunately, 1 or 2 word changes can sometimes make a huge difference. And so it's very important to do it right and to do it right the first time. In terms of Barbara talking about contracts having multiple provisions regarding the same thing, that goes back to the thing that Barbara and I say all the time, and that is it's better to have one complete integrated contract than to have a contract and the group's addendum or rider or whatever you want to call it, because the more you have the hotel contract and what usually is a complete contract that's called an addendum from the group, the more likely you are to end up with those conflicts and problems. And just putting language in that says the addendum will supersede the hotel contract isn't always enough to get you to where you need to be. So negotiate a good deal, keep that deal the way both parties want it. In terms of amendments, Barbara referenced that you should go back and reference the original contract, and absolutely you should. But something I see that isn't really necessary is that people will say, here was the original room block, now here's the new room block. You don't need to put in all the original terms from the contract in your amendment. You can just say the room block is now changed to be whatever it is. You can also say the cancellation clause is now changed to be whatever it is. But as Barbara mentioned, every time you amend a contract, it's very important that you look at everything. If you're amending the room block, then that impacts your attrition, perhaps your food and beverage minimum, perhaps your function space, and your cancellation. So look at everything in the original contract to see how it's impacted by whatever it is that you're changing. Another thing that I often see is a customer will come and say, well, the ABC property accepted this language, so you're in the same chain, you should accept this language as well. You need to understand that part of the conversation every time a contract is drafted is what are the risks here? Are we willing to take them? And if you're booking a meeting in December in Des Moines, they may be more willing, and I can say that because I'm from Des Moines originally, they may be more willing to take some risky clauses, because if they didn't take this contract, they wouldn't have anything. And so the fact that they accepted a risky clause for that particular piece of business doesn't mean that the same chain in New York City in October, their busiest time of year, is going to take that risk. And that leads into the final thing that I'm seeing and that we're going to talk about in the Q&A today is there's lots of I don't want to clauses. And what I mean by that is in this crazy political climate that we're in, and I'm hearing somebody's phone conversation. Are you guys hearing that? Or is that just me?
It's not just you. And I don't believe attendees can send sound, so it might actually be one of us.
It's not me. I don't know. But anyway, let me go on. I'm seeing lots of I don't want to clauses. And by that I mean in today's world in the United States, there is so much confusion going on, and people are worried about politics and discrimination and all kinds of issues, and they're worried about the economy as well, and they're coming up with clauses that they think are protecting them, but the hotels are going to be unwilling to accept them. We'll talk about that more today, but instead of addressing those clauses, it's better to do what Barbara said, and that if you're booking something into the future, it's better to have opportunities to review, work with partner to adjust the block, adjust your commitments to reflect those changing landscapes, rather than just having to get out of the class. So with that, Sean, let's move on to the questions.
If not, we have a team in the background of this webinar work. All right, so I'm going to quickly just go over, because we're a little over time, but we're totally good, on what we're seeing at HopSkip and we collected over, I think, close to 300 or so top challenges across meeting planners and hotels in Q3 today. The top 3 challenges noted by planners and hotels were finding availability, slow hotel response time, and agreeing on contract clauses and terms. So we're going to talk more about those challenges today, but it was interesting to see those as the top 3 for this quarter versus last quarter. And I also want to mention too that anyone who has a question throughout this webinar, we encourage you to submit the question via the chat tool. We'll try and cover those in the webinar live, but if we don't, we'll 100% use them for future webinars. So please, we encourage you to submit questions and feedback. All right. Before we jump into the Q&A, we're going to start with a poll question on the topic of challenges. So this first one will be based for planners. And what is the top challenge today that you faced so far when sourcing events in Q3 of 2023? There's going to be a poll. Looks like it's already launched. The audience should be able to see the answers as well. Let us know, guys, if you cannot. We'll make sure we share them. But it looks like right now, compression, which was the top challenge what we saw at HopSkip as well, is the leader. Thank you to everyone too for participating in these polls. It makes the webinar a lot more engaging. All right, so the winner was compression. And we're going to talk a little bit about that too later in the webinar. The next question is for hoteliers. What is your top challenge in booking events today with your planner partners? All right, looks like the results are coming in. All right. Looks like agreeing on clauses and terms is the top one. Not a surprise there. Still trickling in. Thank you to everyone who participated in those both. We'll also share the results as well as we share the recorded webinar next week. All right, first question. Can you break down the most common types of insurance coverage that meeting planners should require from hotels and vice versa? Barbara, do you want to start with that?
Sure, I'll start with this. Insurance requirements and the contracts, they really span the gamut. Certainly hotels look for insurance, as do convention centers and all types of vendors. And, just to level set, insurance is a way that the parties can manage their risk, right? You pay premiums to a company. If something bad happens and there's a claim, the insurance is your backing. So when a hotel allows a group to come in and there's potential then for damage, they want to know that the group has that financial backing. Similarly, groups might ask the same of the hotels and making sure they have insurance in case something bad happens at the hotel's fault. All that is to say that sometimes in the contract, you'll see insurance clauses that are more broad. They might say things like, the parties represent and warrant that they have sufficient amounts of insurance to cover their liabilities under the contract, and then you get into debate what's sufficient, et cetera. Other times you're going to see very specific types. So the main insurance that many of you are familiar with, commercial general liability insurance, sometimes called CGL for short. And that typically covers, personal injury, property damage, et cetera. Pretty broad policies. So sometimes you'll see reference to that. You'll see reference to a dollar amount coverage in a contract. It's important that you say that, if you're going to say in the contract that you have that insurance, that you do. And similarly, and I'll let Lisa kind of respond on the hotel side, when you're bringing in vendors to work at your meetings and events, it's reasonable for the hotels to ask or to put in the contract that there's going to be a requirement that the vendors themselves show proof of insurance before they come in and work at the hotel. And again, it's a risk management strategy, Lisa. I know, you counsel hotels on the other side, probably on that same issue.
I do. And Barbara's right that you have to keep in mind that every hotel, even the smallest ones you work with, are a multi-million-dollar asset. And so they're going to have liability insurance, whether or not you're coming to their hotel, because they are at risk every day of something going wrong and them getting sued. So I often see these very complex insurance demand clauses from groups saying you're going to have X, Y, and Z. And the hotel has the insurance that it has. It doesn't change for particular people coming into the hotel, which is probably why you get pushback on those kinds of things. Again, the hotels are going to be heavily insured because they have to be in order to protect themselves and operate their business. Another thing I see is groups ask to be named as additional insureds on the hotel's policy for the event. Most hotels do not agree to do that because it requires them to go to their insurance broker for every group that comes in and get a new certificate of insurance that adds additional risk to the insurance policy. It can change their premiums, and it's a pain, frankly. They'd have a full-time person just getting certificates of insurance, which is why they don't do that. They may ask you to name the hotel as an additional insured on your group policy. That's a little bit easier process because you're just having that one meeting at that one period and you're just making one call to your broker to ask that. Usually it can be done at little or no cost to do that. But getting back to the vendor aspect of it, Barbara's right. There's a big risk when you're bringing in outside vendors, depending on what they're doing. If it's a florist delivering bouquets, maybe you don't need to worry about them having insurance. But I literally had one yesterday where somebody wants to bring in Polynesian fire dancers. Needless to say, you need to make sure that they are not only qualified to do what they're doing, but that they have sufficient insurance that if something goes wrong and God forbid they light the place on fire, that they're going to be able to pay for the damage that they're causing. So you have to look at every vendor and remember that every vendor having insurance helps not just the hotel, but also the group, because the group usually is obligated to indemnify the hotel or pay the hotel back for any damage that happens during their event. So if their vendors have insurance and something goes wrong, the hotel can look to that insurance rather than asking the group to indemnify. So insurance helps everybody. It especially helps when you have social events, because when you have liquor and dancing, that's when things can go wrong. So we really recommend that even for social events, that insurance is very important.
Yeah, and I'll just add, Lisa, comments in the chat about liquor liability, as you just alluded to, making sure that there's coverage. It's a common exclusion on the commercial general liability policy for liquor claims. And so in order to get coverage for that, often the groups need to pay more and get a rider or certificate to have that coverage, which you want, even as a social host of liquor. And that's a topic in and of itself, as you know. But
yeah, that's a whole.
Yeah, exactly. Definitely. Great question. Great discussion. Sean?
And let me add one thing, because one of the questions was, is it common to require additional insured when it's a rooms only contract? Most of my clients do not require additional insured in rooms only. They don't even require insurance because you're basically transient guests, even though there's a whole bunch of you. So usually there's not insurance or indemnification in those agreements.
Excellent. Thank you, guys. And for the audience, before we go to the next question, does there sound better? Sounds like it is from some of the comments. Okay, great. Thank you. Appreciate it. Sorry about that, guys. Next question. How can contracts be structured to offer some level of protection against economic downturns? Are there any clauses that either of you would recommend?
Well, if I can jump in first on this one, because this is one of those I don't want to clauses that I mentioned earlier. The problem is that a hotel contract is a futures agreement. You are agreeing today on the terms and conditions for buying inventory from that hotel and services in the future. So you're locking in those terms. Both parties are taking a risk. And if it turns out that the contract isn't as good as you hope that it would be, that's the risk of doing business. If you're not certain that you're willing to make those commitments, then you shouldn't be locking in the contract now. So whenever somebody says, well, I want to be protected if there's an economic downturn, my response is the same that I give when they ask for a no lower rate clause. Okay, I'll let you change the rate if the economy goes down, but will you agree to increase the rate if the economy goes up and prevailing rates are higher? And of course, they say no. So you're asking the hotel to assume risk of the economy over which it has no control. And you're asking the hotel to enter into a contract that isn't really a contract because it's subject to change down the road depending on the economy. And so you're going to get a lot of pushback on those kinds of things. So what's your solution? Instead, Barbara, I'm sure will say, book conservatively, book shorter term if you're worried, do things like that. Change your contract commitments rather than including a clause like this. Barbara?
You took the words out of my mouth, Lisa. Absolutely. And, I think the point on this is that I'm not a fan of any clause that speaks to economic downturn or complex discussion of CPI and all the rest. I don't see those as workable. I understand the concepts behind it, but I don't see it as workable. We've all experienced situations in which your pickup at the meeting may have nothing to do with the economy. It may have to do with the city. It may have to do what's going on within your industry. It may have, a number of things, right, that could impact your pickup. So absolutely, my strategy on that front, to be cautious, my strategy would be build flexibility in the room block, in your room block attrition, food and beverage minimums to the extent that's an issue, but also site selection. If you have a concern about rates and the concern you believe is justified because there are lots of lower priced options around, that's something you're never going to probably manage. In other words, folks booking at lower priced hotels and walking down the street. So that's a site selection issue. You'll want to be aware of that. You'll want to address it. But I think the best thing that groups can do nowadays is negotiate the best rate that it can for what it believes to be for that year. And also for groups, and this is common, many of you look at what was your rate for the year before, because that will impact for your attendees. And so there is a way to measure some of that. But all that is to say, thinking about that, negotiate the best rate, negotiate the flexibility that you need. And then whether it's the economy or something else, if that, hope for the best, plan for the worst happens, you have options within the contract itself.
Perfect. Let's go to the next question. Thank you, Barbara and Lisa, for that great explanation. The next one is timely for today. Following the example of Maui, how flexible can the timing be around force majeure clauses? What is the legal significance of the traditional 10-day advisory period? Either of you want to start on that one?
Sure, I can jump in and say that, the 10-day advisory period is kind of traditional. It's one of those things nobody knows where it came from. It's just been there forever. And I will tell you that I never include it because I don't think that there's any particular day. Every force majeure can be a moving target. If we learned nothing during the pandemic, it's that we learned what may be happening today isn't necessarily happening 6 months from now. And so I think that 10-day advisory or 10-day notice period isn't helpful for anybody. And in any force majeure, the important thing is communication, because I have clients on Maui. People were calling and saying, well, we're not supposed to come to Maui, or can we come to Maui? Well, it depended on where the hotel was on Maui. And while they were trying to evacuate everybody, they didn't want new tourists coming in. But within 2 or 3 days, the state was begging people to return to Maui because their economy is so dependent. And so that's dependent on tourism. And so that's why I don't have a 10-day notice period. What I want is the parties, when they think something is happening, to communicate and say, what do you think? Well, maybe let's wait 10 days and see how it's looking in 10 days, or let's wait a month, depending on what it is, and see how it's looking then, rather than having some locked in period that may make people make decisions that turn out to be not best for either side. Barbara?
Absolutely, 100% agree with you, Lisa. When I saw the question, I said, what 10-day advisory period? But I see it, of course, like you in the contracts. I don't put it in there because we need to have the flexibility. As you point out, the main issue is whether the clause is triggered. So as you all know, the first part of the clause is going to be that grocery list. Certainly the tragedy that happened in Maui was something that would otherwise be covered on that grocery list, if you will, of bad things. I say that and pause at the same time because many of you are accustomed, going back to my be careful category, many of you are accustomed in a force majeure clause to see including but not limited to at the beginning of that list or at the end, and any other cause beyond the party's control, the so-called catch-all statement. Well, I can tell you that there are lots of clauses out there now that do not have a catch-all statement. It will say any of the following events, and it'll list 5 things, and that's it. So if what happened in Maui wasn't one of those 5 things, it's not covered. So just a cautionary tale on that front. Then, of course, it's that standard of impact. I know there's discussion in the chat about that standard of impossibility being, no way, no how. Obviously, tragedy to the extent that your meeting might have been at a hotel or, that would have been, affected by what happened on Maui. Absent that, you get into situations like Lisa described where, it isn't impossible, but the lights are on at those hotels, right? But getting there might be harder, more expensive, et cetera. So that's really the key points, I think, in the clause. But moving away from the 10-day period, I think that's just not reasonable because a lot of these force majeure just develop. And of course, I absolutely agree on the communication piece. I think that's important. Yes, please, Lisa.
The challenge with the force majeure clauses is not real force majeure. The problem from the hotel side is when customers are claiming force majeure when it's the hotel's belief that the event could go forward. And somebody in the chat said something about, and I couldn't read the whole thing, but it was something about the city is fine, but it's become an island because of something happening, and you'd have to put everybody in helicopters or boats. Okay, yes, maybe the hotel is open at that point, but maybe it's just not feasible to get the people there. That's why those conversations need to take place and say, what can we do? Is there a way we can overcome whatever this challenge is, or is it just unreasonable and you can cancel? So that's why the clauses are getting tighter, because hotels have experienced so many situations in which customers used it as a way to get out of a contract they didn't like, that the hotel disagreed with. But there should always be that communication, and it should be realistic about whether or not you can actually go forward.
Yeah, Lisa, just one quick note, because we've got a good comment in the chat about the frustration of purpose language in some contracts and specific language regarding COVID or the like, and having extra options, if you will, or extra steps, and kind of what our thoughts are on it. From my standpoint, COVID or any other, gosh forbid, a similar circumstance is going to fall on the grocery list, and we have to go through the same analysis that we've been talking about. The fact that there would be what I've experienced with this language is that it often puts in extra steps, extra requirements in order to trigger the clause, or extra requirement in order to rebook a meeting. Of course, the latter are things that the group and hotels are going to talk about, of course, but I'm not a fan of most of those clauses. Of course, it's all going to depend on what the language says. But that said, I don't see a need to call it out separately. I understand maybe why it's being offered up, but from the group's perspective, I can say that typically it adds more hurdles than the clause itself.
Excellent. Appreciate that. Let's go to the next question. So this is timely because, as I mentioned, one of the top challenges that we've heard from planners in today's landscape is slow hotel response time. So how can planners increase RFP response rate, as well as get hotels to respond faster? So I'll take the first stab at answering this before passing it to Barbara and Lisa, because all we do on HopSkip is RFPs. So the first piece of advice I would have is to make sure that your RFP is complete and accurate, and it's clear and provides all the critical information up front, so that hotels know exactly what you're requesting, and a well-defined RFP is going to be making it easier for hotels to provide an accurate quote quicker. Second piece, if you do have flexibility in your dates, state that. If your event dates are specific, that's obviously, and you can only do that one date, you're obviously a little pinned down there. But if you're willing to review proposals for multiple date ranges, that will increase your probability of receiving higher proposals or higher proposal submissions.
The third, is specifying deadlines. So in every HopSkip RFP, planners are mentioning or stating when they need responses back and when they're going to be estimating a decision to be made, which provides hotels an expectation for timely replies and allows you to move forward with the booking more efficiently. Last two that I would recommend would be prioritizing, your target hotel list, limiting the number of hotels you're sending the RFP to, which I know can sound somewhat contradictory because when you're not getting a lot of proposals or responses, you might want to do a spray and pray approach. But having a targeted approach really increases the likelihood of getting prompt responses that match your request needs. Last two, I know I said that there was two, but there's actually another one. So transparent budgeting is going to be a top one as well. If you're not transparent with where your budget lies for your event, hotels can be spinning their wheels when they might not be the best fit or best match for your booking. And then lastly, leveraging technology. We know from talking to thousands and thousands of meeting and event planners, some planners are leveraging technology, but a lot of planners are doing the homegrown approach, calling hotels one by one, emailing hotels, having to compile all of the different proposal information from each and every single hotel that they requested, and then comparing all of those proposals, trying to compare them apples to apples. It's very complex. It can be very timely, and it can get messy quick. So the recommendation there is leveraging technology, using a tool like a HopSkip to be able to streamline that process, keep you in control as the planner so that you can source and contract your booking efficiently. Anything you want to add to that, Barbara or Lisa?
I would add, be realistic in your time. When you talked about deadlines, be realistic and give them more time to respond. People are saying, well, I'm not getting full responses. If people are rushing, as Barbara's talked about several times today, they're not doing a good job on either end. And so I think we've all become so used to doing everything immediately because of technology that we don't give the other side time to do a complete job of responding. The other thing is while using technology is great, if you're not getting the answers that you want, pick up the phone and call the director of sales and say, hey, I sent this over and I haven't heard anything. Is there something I can do to get this to work out? So those would be my two big responses.
Yeah, and I would just add to that, agree with what you and Sean said. I would just add to that for groups, especially association groups. You may think that everything, your name says it all about who's coming to the meeting, but we know that your organizations are complex. So it's a good strategy to really put up front, maybe in sort of so-called pink neon flashing lights, that your group that coming are, the top procurement people from, Fortune 100 companies. Make it enticing. I've jokingly said over the years that make your RFP like a personal ad, right? This is why you would want our business, right? So I think that's number one. Number two is that I do have, again, a lot of groups will ask me, should we put our deal breaker clauses in the RFP, right? Should we say that up front? I don't think that's necessary, but what I do recommend to those groups is say something in the RFP as to what's going to be important to you. For example, you don't have to have this exact language about construction, but we need a construction clause that says that you're going to tell us about it, we're going to talk about it, and we'll have a dialogue, right? Whatever the case may be with your particular issue. I think it's good to get some of those parameters out there, if you will, but I don't think you need to do a battle of the language and forms right from the start. I think you get your arms around the concept. And that actually, there was some discussion in the chat, by the way. Thank you all for doing that. It's very helpful. It makes these come alive, and we appreciate your involvement. And, there's discussion in the chatter about, the battle of the forms, kind of we were talking about earlier, Lisa, the, overriding with the, slapping on the addendum, et cetera. And I will say oftentimes, and I think there was a comment about saying, we never change this clause, forget it, like hands off, right? if you, on the other side, whichever your side you're on, are able to explain what your issues are with the clause, I think that's a good strategy. Or if need be, draft a clause that addresses your issues, in light of that. I think at the end of the day, it doesn't do either party a service to say, no, no, no. I think the better way to react is, what's your concern? And then what I tell my clients on the group side, say to the hotel, look, I have to go, in order to get this contract approved, I got to go take it to my board, and I have to explain to the board this isn't helping me sell the business. I can't sell your hotel if we've got this issue, right? So that might be another way to approach it. But again, going back to the RFP, I'd say any of those hard parameters, issues, I'd say put those in there, but I wouldn't overwhelm it, because I'm confident that, at the end of the day, if you get a match and they want to date, they want to meet, right? That, you can address those things in a little bit more detail up until the time. Sean?
Excellent. Great points. Thank you for adding both of those.
I am seeing in the chat, everybody saying the other side is setting too many deadlines. I agree. Everybody needs to give everybody more time.
Good. Well said, Lisa. And I noticed also from the chat, this is something we should also call out as well. This is a trend we definitely saw in the challenges collected or submitted by hoteliers. Hoteliers also noted, planners, that they're experiencing slower response times on communications. They're sending planners or waiting for, to Lisa's point, decisions to be made. So it's definitely an interesting time in the market for sure. All right, next slide. We're going to actually do a poll question regarding the slow response rates, slow response times for planners on average in today's market. How long does it take for you to receive 70% or more hotels to respond to your RFP? All right, looks like the results are coming in. Everyone should be able to see them. Again, if you can't, we will make sure we share this with the recording. But it looks like the winner right now is 3 to 7 days, followed by 7 to 10 days, and then 10 to 14 days. So,
I think 3 days is really fast.
Yeah, I wasn't expecting that number either, but we also don't have a benchmark to compare to from asking last quarter. So we should next webinar, which we have quarterly, we'll ask the same question again and see how it compares. But we will go to the next question now. If a venue has listed reserved next to a clause like dispute resolution and then deletes it, what are the legal implications for both parties?
Barbara, you want to start?
Yeah, I think the intent with this is that means that the clause, if it's deleted, obviously the clause won't apply. It won't be part of the contract. I think the better way to phrase that, if that's the case, I don't use the term reserved. I would use the term intentionally omitted. And part of the strategy with keeping in, if you have a contract that's numbered, is that you have the same numbering scheme so that any other clauses in the contract that refer to section numbers aren't going to get messed up, right? When it comes to that. I would be concerned if I saw this term, Lisa, in a contract, but then the clause was also still there, because obviously that really opens it up. But that's been my experience when seeing that terminology. How about you?
Yeah, I agree. People that have numbered contracts, instead of deleting the whole thing, delete part of it and put in reserve. So it's like, yeah, this no longer applies. I think everybody should be good enough at using Word now to just delete the entire thing rather than causing confusion. And if it bollocks up your numbering, then take the time to go through your contract and make sure your numbering is right. That's what I would do.
All right, great. Let's go to the next question. What are the must-have elements in a cancellation policy to ensure it is fair and comprehensive for both the planner and the venue? Barbara?
Well, I think.
Okay, go for it.
Okay, go ahead, Barbara.
Yeah, no, Yeah, absolutely. Well, I'll just jump in, and maybe I don't want to steal your thunder, but just to say that, I think the question implies a cancellation policy that would be a fee, cancellation fee provision, right? If you cancel certain time out. And, what we're talking about are liquidated damage clauses. And in order to be enforceable, they have to be reasonable estimates of the party's damages. And the reason those clauses it's a thing, right? It's an agreement, is because we can't really ascertain the exact amount of those damages because of various factors. So building a sliding scale schedule is often a good strategy. Now, in this instance, we're talking about a group cancellation. The reverse is that many of you see mutual cancellation fee clauses in contracts. And I think that's a concern, because when we talk about a group cancellation policy, we can think about hotels' losses being attributed to not getting room revenue or food and beverage revenue. If you use those same numbers and apply it to the group's losses, if the hotel cancels on it, those numbers may not have anything to do with the group's losses, which are going to largely be tied to finding a new location for its meeting and all the differentials and everything else that goes into that. So I'm not a fan of the mutual cancellation fee clauses. I think, Lisa, we agree on that point. My better strategy is having a group cancellation clause that the group negotiates, again, factors in, the closer the meeting, the higher the fees, and then it relates to hotel cancellations. And by the way, I say in this instance, hotel cancellations, don't forget those of you who book convention centers, these are cancellation policies in there too. The possibility of the venue canceling is often addressed in that contract too. So you'll want to look for that. I would speak to it more as a hotel being responsible for those types of what we would call direct damages, that the group would essentially put together a summary to say, okay, because we had to move our meeting, these are our costs that flowed from that cancellation. So I think at the end of the day, that's the way I would approach cancellation in a reasonable business manner. That goes back to my point number 2. Be considerate. Lisa?
I agree with everything Barbara says. I think the first thing you need to do is understand what the law of liquidated damages is, because I get so many clauses and comments from customers saying, you're required to do this, which is simply contrary to the law. Liquidated damages do not have to be based on profit, and liquidated damages do not have to include mitigation. That's why the typical hotel cancellation clause has a sliding scale that adjusts as you get closer to the meeting date, and that is designed to estimate the mitigation or the ability to resell. The law does not require anything more than that. Hotels may agree to give you resale credit, but if they do, you have to have a very specific clause outlining how that resale will be determined and what credit will be given. So if you just say less rooms resold, you've just bought yourself a dispute. And I'm seeing the trend I'm seeing recently is customers saying, you didn't do enough to try and resell our rooms. The reality is that the hotel has 500 rooms in the house, and when you book 200, they don't book them by room number. So when you cancel your event, they can't say, oh, this group canceled, we have to sell room 2022 first because it's this group's canceled room. It doesn't work that way. The hotel just puts the canceled rooms back in their inventory and resells them with all of their other inventory. So you have to have a clause specifically indicating how that resale will be calculated. And as Barbara said, mutual cancellation clauses are not appropriate. The damages that the group suffers when the hotel cancels it have nothing to do with the losses that the hotel suffers if the group cancels the hotel. Usually, I don't like to have a formula, and I do this out of fairness to the group. I don't want to have a formula in the hotel canceling the group, because it could be that the group suffers very little damages, or it could be that the group suffers really high damages. And that doesn't depend on when the cancellation by the hotel happens. It depends on what it is the group has to go out and find another venue. So from the group side, it's not smart to lock in the damages because they can vary so significantly. And the last point I'll make is I'm seeing lots of clauses that say hotel cannot cancel group for any reason. That's not going to protect you. No court is ever going to say this hotel has to have this event. They're always going to say you get money damages. That's sufficient to protect you. And so don't rely on a clause that says hotel cannot cancel you, because that's not going to work for you. It's better to have a clause that says a hotel will pay the damages that you.
Yeah, I just echo your agreement, Lisa. And sometimes when I see that in a contract and I strike that, the group says, why are you doing that? That was good for me. And I said, because your damages are going to be the same regardless. If we took that out and the issue came up, and I think you and I had an instance of this in recent past, say, well, what damages are you going to try to prove anyway? So that's really why. It doesn't mean it's not going to happen, right? We need to address it happening, and you want the predictability of what the strategy would be or what the damages would be in that case.
Awesome. Thank you both. And I know that this seems to be a hot topic in the chat, so I'll quickly try and touch on it now around planners potentially informing hotels the first to respond wins the business. I can back up from the HopSkip side. That definitely isn't the case from what we've seen in our data. And, I agree with all the planners that are sending messages in the chats saying that's not the case for them. They like to make sure that the proposals that are submitted, obviously fit within their event's budget. And some planners were even mentioning in the chat, they're not even going to consider a winner until the deadline in the RFP. And that is what we see on HopSkip side as well. It's definitely not the first proposal that comes in. It's the best proposal that meets the planner's requirements for the event. All right, let's go to the next question here. The next question is around health and safety measures. So how should health and safety measures be legally incorporated into contracts post-pandemic, especially for larger events?
I'll just jump in on this one and say that I don't know they necessarily do need to be included in contracts because requirements obviously we saw during COVID, the hotel has to comply with local laws, obviously, as does the group. I don't think we need to say that in the contract. I do know, though, that a lot of groups might have special requirements that they ask the hotel to comply with. And if the hotel is willing to do that, they're able to do that based on their locale, then, they certainly could put it in the contracts. But what I've seen among my clients would be a trend to developing registration terms and condition for attendees. And in those rules, in those terms, if you will, reference to health and safety protocols without necessarily any particulars maybe at the moment, but just as a placeholder to say that, by attending, you'll agree to abide by these health and safety protocols as the group may, advise them, et cetera. So putting in some placeholder language is more of the trend and more of the requests that I've had from clients, as opposed to putting it in hotel contracts. But if you have particular requirements for your group and you've talked to the hotel about them, I'd say by all means, put those expectations into the contract up front. Otherwise, Lisa, I don't know whether you agree on that point. If it's part of what's required legally, locally, you don't need to say that in that contract.
I agree. Let me jump back to the chat for a second, because somebody says, I put in my contracts, hotel cannot cancel this event to host another event or a more lucrative event. That's not legally enforceable either. It's no different than saying hotel can't cancel the event. So that's not going to protect you. Putting that in won't do a thing. So in terms of health and safety protocols, I agree. Hotels are not putting anything in their contracts about that now. Everybody's required to comply with the law, whatever it is, at the time the event is happening. So if there's health and safety requirements in place, everybody has to do it. I agree with Barbara that it should be the group and the attendees saying that they will agree to do whatever it is that the group deems appropriate for the event. And that should be part of your planning process as the group and the hotel are getting into the final details for the event. Based on the circumstances at the time, they should agree, because you have to have flexibility depending on what's going on. So I agree with Barbara on that.
Great. Thank you, Lisa. We have two last questions. Try and get through them both. Before that, just a call out, if you're looking for any of these topics in resources format, we have a contracting academy on the HopSkip website. A lot of these resources came from the two presenters today, Barbara and Lisa. So they're all free. You can access them, like I said, at www.myhopskip.com. Second to last question. When an event involves content creation or sharing proprietary information, what clauses should be present to protect the intellectual property rights of the involved parties?
Let me start from the hotel side, because I think Barbara's going to have a different take on it. The hotel's position is that it does not need or want proprietary information to host an event and doesn't want to be responsible for it. So in general, hotels push back on anything related to this issue, and they try to shy away from a confidentiality and work it more towards, here's how we're going to agree to protect your confidential information that's in the content of your meeting. Because the hotel doesn't care if you're talking about trademark information or potato chips in your meeting. It doesn't matter to them, and they don't want to know about it. But if you're going to be talking about your secret potato chip formula, they want to help you protect it. And it's very hard in a public setting. I just had a situation this week where an influencer went in to disrupt a meeting and started taking video of the meeting and the hotel employees, and everybody was upset about it. That's not the hotel's fault, and it wasn't something that they were able to control. So we try to shy away from that and try to keep these clauses as narrow as possible. But Barbara, I know from your side, you may have groups that are creating things that are important and need protection. So how do you deal with that?
Yeah, I mean, my take on this question, Lisa, was around the content creation and about the group owning, the intellectual property rights. So if it's a speaker giving a presentation and the group is recording it, have you addressed the rights that the speaker has given to the group? Permission to record, permission to use later, or assigned ownership in that work. Similarly, are the people creating the content, are they your employees, versus contractors? So there's a lot of analysis that goes into the content creation. And if you're doing content creation at your meetings, you want to make sure you're on sure footing, solid footing on who's going to own that content and what rights come out of use of that content. But I agree, Lisa. I mean, if the group is discussing the secret sauce formula, you shouldn't be doing it likely in a public place. And the situation you had is really interesting to me, but it's just one of another example that says groups have to have a crisis response and management plan for their meetings. That thing that happened to that group, right, can happen to any of the groups and in a whole variety of ways. What is the group prepared? What are they prepared to do? All the things that go along with that, I think, is really important. So again, I think focusing on crisis planning and management is always an important strategy, no matter the circumstance.
Awesome. Thank you both. That will be our last question of the day, since we're just at the hour mark now, but we will work in all the questions that we didn't address in the chat into a future webinar. So thank you again for everybody's participation. It was a really great, engaging session. So great to see so many familiar names. And really thank you to Barbara and Lisa for another great Legalese with the Ladies webinar. We do these because we want to make sure we're arming you guys with accurate, up-to-date, relevant information in today's landscape. And it couldn't be possible without everybody's feedback and questions that they submitted. So thank you to everyone, and have a great rest of your day. We look forward to seeing you next quarter.
Thank you.
Have a great weekend.
Bye.
Bye.